All right. So let me share my screen with you here. Um, we are going to look at the slides I have prepared for the final exam review, revised May 2021. So these are not exhaustive, but I hope they will be helpful to you as you go through and kind of look at what we did and where we are and where we're going. So, some general points. As I mentioned, the exam is 100 questions, true, false, and multiple choice, same as the midterm, drawn from a larger question bank randomly. It covers second half material from admin agencies forward, includes environmental law and also the B Corps and Benefit Corps subsections, administered on ICON, dates listed on the syllabus. All right. So the first thing I want to look back at just a little bit is admin agencies. So we did this at the beginning of the second half. So this is probably least fresh in your mind. So I would spend a little time looking back on this chapter because, as we saw, these agencies are actually very important in kind of the day to day of our government. And so remember that they act in the manner of all three branches at different times. You may have them in a legislative kind of function where they're making rules, right? So, recently I saw the EPA was changing rules on methane emissions. So that's kind of like a legislative function. They may have an executive function. So, suppose the EPA wanted to investigate somebody who was, possibly polluting or wanted to make an order that somebody had to stop polluting. That's kind of like an executive branch role. And then sometimes they act in a judicial role. So, one of the um, appeals opinions I read this week came out of the Iowa workers' comp system. And the Iowa Workforce Development has administrative law judges who hear claims on workers' comp and they make rulings. And so that's within an agency and it's very much a judicial function. So they're, depending on the agency, they may exercise some or all of these functions, and that is by design. Remember that Congress ultimately is the um, body that creates a federal administrative agency, and then in the state level, it's the state legislature. But we confine our discussion mainly to federal agencies. So Congress can delegate some of its authority to an agency through an enabling statute, and that's the rules of the game. That's kind of the code that sets up an agency, and it gives everything from the name, the purpose of the agency, how many members or what kind of members are involved, and the function and the powers of that agency. In that enabling statute, there are also ways to kind of control the agency or even end it after a period of time. So some agencies might be intended to go on forever, some might be set up for a specific time, or Congress can even amend the enabling legislation to put an end to an agency in the future if they need to. So we did quite a bit on administrative agencies, and then we got into the special case of environmental law, much of which is administrative law, because we have agencies like the EPA and the Iowa Department of Natural Resource who are there to, do the rulemaking, do the investigation, in some cases adjudicate. Or make enforcement actions if there's some kind of infringement of the law that's going on. So what I would know from this chapter, this module, is the main federal laws, which I have on a following slide here, and then I would also know a little bit about the Des Moines Waterworks case, and that's the one that we talked about with the drainage districts and the drinking water contamination in Des Moines. And the main federal environmental laws that we talked about, we had the Clean Air Act, the Clean Water Act, RCRA, and CERCLA. So I would just kind of go through and just remind yourself briefly what each of those is about. Then in Module 8, we got into criminal law, and we spent quite a bit of time, excuse me, on criminal law is not boring. I'm just tired. We spent a fair amount of time on criminal law because it's a really important part of our society and our justice system. So remember, what are the differences between criminal and civil cases? I got a slide following on that. What are the penalties or remedies that can occur in a criminal case? And here, um, more than probably any other chapter other than constitutional law itself, we really think about what are the constitutional amendments and the big cases that are important to our understanding of criminal law. So remember, the main differences between criminal and civil cases. Well, one of those has to do with the penalties, right? So in a criminal case, somebody's going to jail. They may also be fined, so they're losing liberty, property, and in states that have the death penalty, they may lose their life. So the penalties are much higher in a criminal case than a civil case, where you can just lose some money or maybe have injunctive relief entered against you. Because of that, it follows from that that the standard of proof is much higher in a criminal case. So the state has to prove guilt beyond a reasonable doubt, 99.9%. Okay. Remember, in a civil case, it's just a preponderance of the evidence standard, 51%. A similarity is that in both of these, the plaintiff has the burden of proof, whether it's the state as the prosecution in a criminal case or whether it's a private party in a civil case. They have to carry the burden of proof. And remember, criminal cases deal with guilt, so you can be found guilty or not guilty. Civil cases really just deal with money or injunctive relief, so somebody is held liable or is not held liable. So that's just kind of a nomenclature thing. When we talk about the essentials of criminal liability, remember there's kind of two parts. There is the guilty act, the actus reus, and then there's the guilty mind, which is the mens rea, also called the intent. And you need to have both. So there can be situations where you have only one or the other. There can be some exceptions, right? If someone is under the age of usually 7, courts may find they aren't capable of having the guilty mind, even if they did the guilty act. If somebody is mentally impaired to the point where they can't understand right from wrong, that's the M'Naughton case. You see the picture of Mr. M'Naughton here. That is a situation in which possibly, criminal liability cannot attach. So there are a number of situations here where these exceptions or justifications maybe could apply. Let's go to our next slide here. Major constitutional protections. We really talked a lot about the Fourth Amendment, the Fifth Amendment, the Sixth, and the Eighth. Fourth Amendment, we really think about the warrant requirement in all those cases about when it's okay to search or not okay to search. Fifth Amendment, there's a lot here. Due process stuff, double jeopardy, and the right against self-incrimination. So we had a number of cases there. The Sixth Amendment, the right to speedy trial, the right to a criminal trial by jury. We talked about those some, but then also the right to counsel, and that really comes out in the Miranda case, which we'll mention here in a minute. And then the Eighth Amendment really comes in at the punishment stage. is something cruel and unusual punishment, and what is the court held over the years that constitutes that? With the Miranda case, you'll recall he gave a confession while he was in custody. Um, they had not advised him of his rights. They didn't Mirandize him because that term wasn't coined yet, because he was Miranda. Okay, but they put him in custody, interrogated him, took his confession, used it against him without telling him he had the right to an attorney, that he had the right to remain silent, and that anything he said can and will be used against him, as they say on TV, right? And so he successfully challenged the use. He challenged his conviction based on that confession, which should not have been admitted into evidence. And with all of these cases that have to do with search and seizure, or somebody making a confession that's used against them, the game really is to try to exclude that confession or that physical evidence from the jury's consideration at trial. Okay, so that's usually done in a pretrial hearing. In his case, he had already been convicted, he appealed it, and it was sent back down for a new trial that would not allow the use of that confession he made to the police. Now, of course, he also confessed to his girlfriend at the time. That did come in as evidence. He was convicted again. But when you talk about all these Fourth Amendment cases, or in this case, a Fifth and Sixth Amendment case, this doctrine of the fruit of the poisonous tree is what we think about, and it just says that everything that proceeds from an illegal search is inadmissible evidence. So if the tree is poisonous, then the apples that fall from it, which are the fruits of the search, which is really, frankly, a very tortured metaphor, those are poisonous as well. And speaking of torture, our next chapter was torts. Okay. And you can think of tort along the same line as torture because they come from the same root word. Many of the examples I gave you, somebody was physically injured. Remember that torts can also be financial injuries as well as physical. And they can be, reputational injuries, and in some cases, mental injuries as well. But it's a civil wrong where you breach a duty to another human being or entity, and you unjustly cause them some injury or loss or harm. It's Even though many torts are also crimes and many crimes are also torts, remember that we're dealing with two separate court systems when we talk about torts, that we're really just looking at the civil side of things and the money damages. The criminal side is a separate proceeding. Okay. Um, Criminal law really talks about somebody's actions doing harm to society in general, and they have to be punished through prosecution by the state, whereas tort law is between private parties typically. Negligence is the number one kind of tort. I don't mean to say it's number one like it's the best kind of tort. There's no good torts really, but it's the most common. And most tort cases, I think, are brought under some color or claim of negligence. Okay, because it's kind of like the lowest level of tort for most people. You didn't mean to do something, you weren't acting horribly, but you did have a duty and you breached it. Like maybe you own a store and you didn't shovel the snow and ice from in front of it and somebody slipped and fell. Okay, it's not like you went out and pushed them, but you did breach a duty to them, and they got injured and they had damages. Um, Along with those four things: duty, breach, causation, and damages, which think about those things, right? You generally also need foreseeability and proximate cause. Okay, so proximate cause is kind of easy. It means but for your failure to shovel, that person wouldn't have slipped. Foreseeability is a little bit more difficult. You think about the Palsgraf case, and courts will sometimes say there were too many steps between the defendant's action and the plaintiff's injury to hold the defendant liable. So in that case, there's a guy getting on a train and he fell and he had fireworks or explosives and those went off and the shockwave traveled and it hit the scale and it hit the Mrs. Paul's graph. Okay. And the court was just like, well, there's too many steps in there. So that's foreseeability. Other things that might change your analysis: res ipsa loquitur, which we'll talk a little bit about. Strict liability we'll also mention. And then defenses in tort, like assumption of the risk, superseding causation. So let's dig into a couple of these things a little bit here. Assumption of the risk. The picture I have here is the running of the bulls in Pamplona. Okay, this is outside the US, but suppose we had the running of the bulls in Coralville, right? If you sign up to run with the bulls, likely outcome, I think everyone knows, is the bull may gore you, it may step on you, it may throw you around. This is all on YouTube, of course, if you're interested in these things. Not that I recommend it. Okay, but people know if you're going to run with the bulls, I mean, you've heard the expression F with the bull, get the horns. Like that, this is why. Okay. So if you try to sue whoever provided the bulls for the running, they're probably going to say assumption of the risk. You knew this was dangerous and you took a chance with that knowledge, right? So things like skiing, bungee jumping, parasailing, you're probably going to sign a waiver to participate. But even if you don't, you kind of know, well, these things are dangerous. There are also situations where there's like a third party or another thing that comes in to cause the injury, some kind of superseding causation. I was reading a case the other day and I don't remember what it was. But they're like literally like an anvil fell on somebody's head or something crazy like that that wasn't caused by the defendant. And it was I wish I'd saved that case because it was a great example of superseding cause. But sometimes there's a third party or some kind of like act of God or other outside action that actually causes the injury. Okay. Uh, Defamation. We spent a little bit of time on this. It's wrongfully hurting a person's good reputation by making a false statement of fact. So you have to parse that. If I give you a fact pattern on the exam, look at, okay, was person making a statement of fact? Was that statement in fact false? And did it wrongfully hurt their good reputation? And was it published to a third party? Which is pretty easy if you do it in writing. But if you're speaking defamation, you have to speak it to a third party, not just the person you're wishing to defame. So if I go up and whisper in my teaching assistant's ear, oh, you're, totally unethical, you're bad at your job. Not all my TAs are great, but if I did whisper that in their ear, that's not defaming because they're the only one who's hearing it, right? I'm not publishing it to a third party. But if I post on Icon like so and so sucks at being a TA, I would be defaming them. I would be publishing that, right? So I would just go back and have a little look at the torts of defamation, some of the exceptions, and also look at that New York Times versus Sullivan case and my explanation of that, where if a public figure wants to claim defamation, they usually have to show that actual malice occurred. So have a look at that. Strict liability is kind of a special case for things that are so dangerous that the law imposes a high burden upon the people who do them. So if you are a quarry company and you use explosives, as many of them do, to get the rock out of the quarry or whatever, and you end up shattering people's windows 5 miles away, even though you took all the due care that you should have in using those explosives, they're still going to make you pay for the windows. If you have a tiger in your house and it gets out and injures somebody, even though you took good precautions, you had a good cage for the tiger, or you trained it well, or whatever, you're still going to have to pay for those damages. So when you think about ultra hazardous stuff, think about strict liability. And then we came on to product liability next. And I would just kind of look over that timeline of, we started out with the doctrine of caveat emptor, which is just buyer beware, like tough luck, basically. And then, you move along the line and, then you start to get into some of the contract theory and the privity of contract stuff. And then we get kind of more evolved. We get into the warranty stuff, the negligence stuff, and the strict liability standard. So as the law stands now, product liability claims are tort claims. They come out of, straight up negligence claim, like we talked about, negligent design, negligent manufacturing. They might come out of a breach of warranty, or they might come out of a strict liability kind of setting. And we detail when that occurs, that kind of stream of commerce argument. And then res ipsa loquitur, our old friend, rears its head here again and applies to certain cases where, like, the manufacturer of something, even though they took good precautions in the design and manufacturing, they're really like the only one that could be held to blame. And so the court has, in some cases applied this kind of res ipsa analysis. So like Ms. Escala, the waitress who was carrying the bottle of Coca-Cola and it exploded and injured her hand very badly. Coca-Cola introduced evidence that's like, well, we had everything was intolerance. Like, we don't think we made a mistake on the manufacturing line. And the court was like, look, res ipsa speaks for itself. You were the only one who had control of creating this bottle of Coca-Cola. So you have to pay for the injury. We then moved on to contracts, and there's a whole bunch of stuff there. Remember, when you're breaking down a situation, if I'm asking you if a contract exists, really think about these 4 parts. Is there a valid agreement, first of all? Is there consideration for the agreement? Do the parties have capacity to enter into the agreement? And is the subject matter legal? All right. So remember what is and what is not an acceptance of an offer. So, you've got to generally do something, either a promise for a promise or accept by performance. And remember the mirror image rule at common law that says if somebody makes you an offer, anything less than full acceptance of the offer on that terms is a counter offer that terminates the first offer. So if you get offered a job for $100,000 a year with 14 days of vacation, and you say, yes, I'll accept the job for $100,000 a year with 17 days of vacation, trying to get that little extra, you have not accepted the offer. You have rejected it and counter offered. Okay. So just remember that bit in there. Consideration is anything that's legally sufficient that somebody might want to bargain for. So we had some cases with a weird uncle who offered his nephew $5,000 not to smoke and drink and play cards. Is that consideration? Yes. Is it weird? Definitely. We all have that uncle, right? Although I don't have one who offered me $5,000 not to drink and smoke. Uncles who probably offer me a drink and a smoke. But that was enough. The court said that's enough. Like, okay, this is weird. We don't understand necessarily why somebody would care that much about what their nephew is up to. But the nephew forbore, it exercised forbearance in refraining from actions he had a legal right to do. Okay, so there are a lot of different ways that you can show consideration. Normally, we think about it in pretty easy terms, like money changing hands in exchange for labor. That's how employment contracts work, or a vehicle or real estate in exchange for money. That's how sale of goods and real property work, right? But sometimes it's these other things. Capacity. I just love this clip art of these like really sketchy looking business kids. Um, Remember that you've got to be 18 years old, generally sober enough and in sound mind to enter into a contract. If one of those things isn't true, there may be a way to get out of the contract. And here's just another thing that you've got to kind of keep on your mind when you're looking at contracts a little bit off to the side is our old friend the statute of frauds. Oddly named. It ought to be called the statute about contracts that must be in writing to be legally enforceable. Good joke in the chat. Yes. Doubly voidable, right? Um, so the statute of frauds says that if you've got a contract for the sale of goods over $500, or for real estate, any interest in land, or that cannot be performed within 1 year from the date the agreement is made, or these other three weird ones, which we're not going to test you on, but they're in there. And somebody wants to enforce this contract, it has to be in writing. So if you're going to sell, um, your house, if you're going to sell a bike that's for $600, um, if you're going to enter into a long-term employment contract, those have to be in writing if you want to have them be enforceable later in court. All right. From contracts, we then talked about the UCC. I don't have any specific review slides on that because there were only like 7 slides, but I would go just have a look through those. And then we came to business organizations. So I just want to run down a couple of the forms and when you might find these more or less advantageous. So the first one, corporations. You've got your nonprofits and your for-profits. We spent some time in the kind of like subsection on nonprofit corporations, but we really spent a lot of time in for-profit corporations. And that most of the biggest companies in the US are for-profit corporations, and they are C corps, which is kind of just like the base, the default, right? It's the oldest form of business organization that's incorporated in the U.S. There's a lot of good law about the rights and duties of corporations and their shareholders, and you have, really the strongest liability protection here. The penalty that is kind of paid for that is it is taxed. The money that comes in is taxed twice. We talked about S corps that are small corporations who can make a special election to pay a little less tax, but still get the benefits of the good liability protection. Okay. Then we talked about the limited liability company, or the LLC, and we talked quite a bit about this really flexible entity. You can kind of set this up different ways, get a lot of the liability protection benefits with a good tax status. The downside that we talked about is they've only been around about 30 years, which sounds like forever, but in law is just a blink of an eye. So we don't have a lot of case law and an interpretation on some of the points of an LLC, particularly in the asset protection area. We talked about professional corporations or professional LLCs, how these are for licensed professionals who don't get the benefit of the full corporate structure, the full LLC structure, but it's a way for them to do business and get some protection. We talked about partnerships, the different kinds, the general partnership, the limited partnership, where you have kind of a money partner and a managing partner. And then we talked about the limited liability partnerships and how those are used by some professionals or larger firms. Some of your larger accounting firms will be LLPs, and law firms too. And then last and very much least, the sole proprietorships and unincorporated associations. So a lemonade stand is often a sole proprietorship, assuming that only one of these children is in business selling lemonade. If they are in fact engaged in this selling of lemonade together, then they have formed a general partnership, as we know. at common law. Unincorporated associations are things like homeowners associations, some condo associations, some nonprofits. And then we talked about in the videos the corporate governance model, how the shareholders supply the money to the company, and they also elect the board of directors in periodic elections. The directors choose the executives of the company, or the C-level, CEO, CFO, etc. And those folks hire uh, middle managers and employees. Then we went into the little kind of subchapter on B Corps, benefit corps, and nonprofits. And I would just kind of like familiarize yourself a little bit with those slides, have a look through, um, and remember the difference between a benefit corp and a B Corp. So a certified B Corp is a company, can be any legal entity form, could be a C Corp, an LLC, whatever. Um, that goes through a certification process through an outside agency. It reviews the company's policies and the impacts that they make, whether environmental, labor, whatever, and they get that B Corp designation. So some of these logos that you see in the clip art here, Ben and Jerry's ice cream, this bank, they have achieved the B Corp designation. A benefit corporation is something that we don't have available in Iowa, but is available in certain states. And it's actually a legal entity, just like a corporation or an LLC or a partnership or whatever. It's its own separate form of legal entity, and it kind of makes some legal modifications to the duties of shareholders, and it really requires you not to just make your business decisions just based on pure profit, but also to think about how it kind of affects everyone, how it affects the environment and things like that. Oh, good question in the chat here. Is an electronic agreement also considered in writing? And can an email create venue for an agreement? Yes and yes. So I had a really good question from somebody in the class the other day about ClickWrap agreements. So this going back to the contract chapter. Are ClickWrap agreements enforceable even when they're like 100 pages long and you're not gonna read every bit of it? They generally are enforceable, although some courts have started really getting picky about, was the ClickWrap agreement readable? Was it all on one page, or did somebody have to scroll through it? Did they have to use a link to get somewhere else? And those have been factors that go against enforcement of it. But generally speaking, an electronic agreement is in writing, just like something on hard copy. And in emails and electric document signings and things like that can control jurisdiction and venue. So when you buy something from somebody over like eBay, you've formed an electronic contract, and it's considered formed in the state that you're in the state that the other party is in. Um, Sometimes there are jurisdiction and venue provisions, like eBay may say, and I don't know this for a fact, but it may say like you agree to arbitrate any disputes that you have with your buyer or seller in the state of New York, and you waive the rights to a jury trial in favor of said arbitration. That's getting more and more common. So yeah, very, very good questions there. All right. So we went from business entities into our remaining modules, which really had to do with workers and workers' rights and different kinds of discrimination and harassment, and how those are impacted by law and ethics. So we said the Title VII of the 1964 Civil Rights Act is really the big law that set the stage for anti-discrimination law at work. Um, so it set out certain protected classes: race, color, creed, religion, national origin, and gender. And it said you can't discriminate against people at work based on these protected classes. We then went on to show how additional protected classes have come in, and additional causes of action based on these original ones have come in. Remember that the federal law covers employers with 15 or more employees, so not the smallest of small business, but sweeps in most of them. And that we have an administrative agency, which is the EEOC, to administer and enforce Title VII. Also, remember, in some rare cases, there are these bona fide occupational qualification exceptions where you might be able to discriminate against somebody based on, for instance, religion. If you're hiring a priest for a Catholic church, um, it maybe is legitimate that you say only Catholics can apply, right? But those are very narrow exceptions. You couldn't say, for like a I don't know, police officer, you couldn't say only Catholics can apply or something like that, right? It's very narrow exceptions. Also remember that we have state and local in Iowa civil rights acts, and laws and rules that are administered by our agencies. In Iowa, it's the Iowa Civil Rights Commission, and then there are local. There's like an Iowa City Civil Rights Commission. So in Iowa, our state Civil Rights Act adds some protected classes. They add in pregnancy, which is protected at the federal level, although by a different law. Um, we add in age and disability. Again, those are protected at the federal level as well, but by different laws. So our state act kind of sweeps all that in. And they sweep in more businesses. So if you've got 4 or more employees, you're covered by the state law. Um, Cities in Iowa, which I think is defined as any metro with more than 29,000 people, um, they have local civil rights commissions as well, and they can choose to rule make and add additional protected classes. Like I believe Iowa City protects um, sexual orientation, um, which not everywhere does. We talked about the Americans with Disabilities Act, and we said that employers have a duty of reasonable accommodation. It means they have to provide reasonable accommodation to qualified persons, um, so people who can do the functions of the job with or without an accommodation. And they have to do that as long as it doesn't impose an undue hardship. So for that, we looked at things like cost, size of the business, the mechanics of it. A reasonable accommodation is intended to put a person on a level playing field with others, and it's some modification of the work or the environment that allows them to perform the essential functions. So if you had a visual impairment, maybe you would get a larger computer monitor or a screen reader that could read you what's on the screen, right? If you have a back injury, it might be, either a piece of furniture that makes it more comfortable for you, or a job where you don't have to stand as much, depending on if that's possible. We also talked about sexual harassment as a form of gender discrimination. So, although it was not written into the 64 Civil Rights Act at the time, the U.S. Supreme Court later held, yeah, this is gender-based discrimination. Men and women are protected, and they are protected no matter the gender of the harasser. So whether it be same or opposite gender. Um, Sometimes people ask, what about transgendered folks? I'm not aware of any cases, U.S. Supreme Court cases directly on point with that. But typically, if there is sexual harassment based on gender, it's legally prohibited. I have seen some lower level appellate court decisions that say that. And remember, the definition of this is unwelcome verbal or physical conduct of a sexual nature. Types, quid pro quo, this for that. So conditioning, like promotion or some kind of employment action on, sexual favors. That's one part. The other type would be a hostile work environment where people are, engaging in behavior that they're not offering you a promotion or something. They're just sexually harassing you. And it could be a boss, it could be a coworker, it could even be a customer or a vendor. And then the final module that we went into was workplace respect and bullying. So this we went into and showed that not all harassment is technically illegal at work under the civil rights framework we have. It is always unethical, and it is still very harmful. So we talk a little bit about abusive supervision, but we talked a lot about workplace bullying, which, because it is not generally motivated by a person's membership in a protected class, we don't always have the same legal remedies, but it really hurts people and organizations. And so I would just kind of have a look back through that. Remember how bullies choose their targets. It's not based on weakness. It is usually based on somebody feeling threatened by somebody who is kind of like up and coming, and they're afraid that they may eclipse them or even take their job. And some of the factors we look at as to what is bullying and what is just kind of like bad behavior at work. Well, there's an intent to harm or destroy the target psychologically or career wise. And it has to do with attacking the person rather than the task. We all know bosses who are very hard on, they want a high quality work product. Um, that's okay, within reason. But it's not okay to try to, criticize the person personally and just try to attack them. And a lot of the costs that we talked about, people leave organizations because of this. They take clients with them. Um, People miss work or they're at work, but they're not fully engaged because of the disruptiveness of this behavior. In some cases, there is litigation and settlements under frameworks like IIED lawsuits. And then I talk a little bit about workers' comp and disability and how that takes a lot of the costs of this. Of course, those costs eventually accrue to not only the business but all of us as we have to pay for those things. So that's the substantive stuff. Just a few final tips on the final exam itself. Um, Make sure to leave yourself plenty of time, so don't start at 11:30 p.m. on the last day, because if you do, um, it's going to submit at 11:59 and 0 seconds. So leave yourself plenty of time. Do set up your computer and test it ahead of time. So this is not Proctorio or ProctorU or anything. This is self kind of, this is Tippy honor code. But make sure your computer is working before you take the exam. And then I would recommend, if you're a Mac user, to turn off notifications during the exam. I have had reports of the exam crashing more when we use Proctorio, but if you're getting those notifications and things coming in, it can mess with Icon and kind of screw things up. So I would turn off your notifications during the exam.